Hello, my name is Professor Brett Davies. I'm a barrister and solicitor. You are building two wills. They're mirror wills. So mum leaves everything to dad, dad leaves everything to mum, and then you can distribute to all the children equally, or some of the children to charities, or whatever you want to do. But they're mirror wills. So whatever you've got in your will, your spouse is going to have in his or her will as well. What is the advantage of this document is that it is tax effective and has choices. So let's look at the tax effective nature of what you're drafting. It's tax effective because there are 3 de facto death duties available to the Australian Taxation Office and to the state government, and they are capital gains tax, stamp duty, sometimes called transfer duty, and income tax. They're the 3 things which are de facto death duties. Now I know what you're saying. You're saying, but Dr. Davies, Paul Keating introduced capital gains tax in 1985 and he expressly said, and I remember it now very well on the budget night, he said it will not be a de facto death duties. Well, you've got a very good memory, and he did actually say that that's quite true, but the majority of people will end up paying, if they're middle class, not the poor people, not the rich people, but if they're middle class, will generally end up paying a lot of capital gains tax when their children then dispose of the asset. There's lots of tricks there, joint tenancy assets, treated as tenants in common. There's a lot of rude things. Family homes pre-85. So a family home that is pre-1985 can still be subject partly to capital gains tax. Oh no, that's not true. That can't possibly be true. It's a pre-1985 asset, so it can never be. Not true. A man, he did a development of $70,000, a $70,000 development on his home. He then ran a stamp collecting business from his home. That is a separate asset for capital gains tax purposes. When he dies or disposes of the asset, when his family disposes of the asset, there's a capital gain, potential capital gain there. So be very careful. The tax legislation is the largest piece of legislation in Australia. The second largest piece is the Corporations Act under companies and things. But the biggest piece of legislation is the Tax Act. We've got the 1936 Act. They rewrote it to the 1997 Act, and now they've got both of them. We had to have both acts. So instead of getting rid of one, we've got 2. Plus there's 36 other acts, and there's over 14 acts relating to self-managed super funds and superannuation. So there's a whole raft of different problems. That's where you've got to stay close to your accountant and your lawyer. So you're drafting mutual wills here. You are going to have lots of choices. If you're going to get a divorce, you can put the person you're going to divorce. You're going to get married, put that person in. Lots of different choices. Enjoy the experience you're about to go through, and remember that you are drafting your mutual wills with choices that are tax effective on a law firm's website. And that means that everything you've got here is legal advice. Retain legal professional privilege. You can contact us, because we are lawyers. I'm a lawyer. There's no programmers here. You can telephone us for legal advice. We can help you answer the questions. So be very careful who you deal with. If you're dealing directly with a law firm, then you gain potentially additional advantages such as legal professional privilege and professional indemnity insurance and other advantages which you can read on our website. So enjoy that and telephone us if you need a hand.